I don't know if not sure if my headset's on. Okay, are we going?
Yep.
All right. Okay, so last week we talked about identification of a change and notification requirements, both in Hawaii state law as well as the spec. So we're going to continue on with differing site conditions. So when we talked about identification and notification, a lot of that had to do with making sure we comply, we don't waive our rights, that we're not prejudiced. So we're going to go through more and more of that, and then we actually added one more session. We got some feedback on having examples and written responses that you guys can use as examples. So we're going to throw some of that into next week. So next week will be a little bit of a deeper dive into some notification examples as well as responses and this as well. So make sure in the chat, if you have questions, if you want to take deeper dives into things, let us know and we'll compile that for next week. Okay, so let's see if I can move this thing. So there's two in, and this definition actually aligns with the FAR. It aligns with the state law. It's all very similar. So two types of differing site conditions, subsurface or latent physical conditions at the site, the differing materially. So we're going to talk about what is materially. I think that's one of the big criteria. And obviously when we're talking about this, as engineers, we want everything to be very clear cut, and this is not clear cut. So you have to use your judgment. You have to look at, other circumstances, what else is going on in the DOT and then the world. And does a reasonable person, that goes back to good faith contracting, would a reasonable person interpret these things? So we have a couple examples, and that's why I thought it would be good. This is one of those little bit difficult. I know I've had what is that? There was an excavation. I don't know if Willie's on. There is a whole quarry buried under one of our jobs. Obviously, a reasonable person shouldn't assume that there's going to be a quarry in the buried under their job. So things like that become obvious. But I think that same job had one of those boring examples. When you have geotech subsurface investigation, you're not going to be able to do it everywhere. So are the borings provided? Does that give you enough reasonable information to make a decision on what the subsurface conditions should be? So it's a little bit tricky. Again, part two of this is unknown physical conditions at the site of unusual nature. So if a boring kind of shows, rock here, and for some reason the rock between the two, it makes sense that it should follow, some kind of curvature. But if you can't extrapolate that from the drawings, doesn't make sense. So it's that kind of evaluation that we go through with differing site. So unknown physical conditions at the site of unusual nature, which again, differ materially. So what does materially mean? From those ordinarily encountered and generally recognized as inherent in work of the character provided for this contract. So we'll talk a little bit about that stuff. Okay, so again, the HAR, very similar. This is our state, closely mirrors the FAR. So everything kind of aligns with this differing site condition expectations, requires immediate notice. And this is key because we're going to go back to that term of prejudice, requires immediate written notice before disturbing conditions. So that gives the owner the ability to go in and do an investigation, and does it materially differ? When the contractor doesn't do that, they are waiving, or they're prejudicing the owner. So we're going to talk about that. Requires investigation, equitable adjustment if warranted. So we didn't have time to go through the investigation. So we do have kind of a checklist that we're copying from one of our references. So that's what we'll go through next week. What does that investigation look like? What does the checklist look like? And the engineer obviously is the first point of determination. Okay, so 108 or 104.8, again, verbal notice within 12 hours of discovery or by 10 a.m. the next working day, whichever is later, and the differing site conditions. So they have to provide notice. Written notification of the potential claim to the engineer no later than 5 days after the discovery. And then usually after that, you're required to receive more in-depth information within 30 days and all the information within 6 months. So that's the infographic hopefully our MDG interns are working on. So we got our notice, and then upon reading notice, the engineer shall promptly investigate the site. So that's the site investigation checklist that we are going to go over next time. And if conditions are found to materially differ and impact the contractor's cost or time or performance, an equitable adjustment will be made and incorporated into the contract through a change order in accordance with 104.06, which is our change order provisions. No claim after final payment. I think, again, this echoes the HAR. So no request by the contractor for equitable adjustment to the contract shall be allowed after final payment. Obviously, in those scenarios, they've waived their notification. There are other implications with not providing that information. And then nothing contained in this subsection shall be ground for adjustment in contract or price or time if the contractor had knowledge of the existence of such condition prior to the submission of bids. So lots of stuff there. We're going to go through it. Okay, so some of the case law examples might be coral or rock subgrade, that it's anticipated to be compacted subgrade, but instead they encounter extremely hard coral, blue rock, those kind of things that happen. And how come an adjustment is granted because there was no indication of that in the borings. So that's one example. Another example might be hitting water at a level that was not indicated in the plans. And again, in that scenario, adjustment was allowed in the contractor, especially if they're relying on groundwater. Maybe it's typical in the area, and this was an atypical example. This case, actually, this happened in the 90s, so I was trying to find the write-up, but encountered solid lava rock that was not indicated in the contract. The interesting part of this, and this is the part that's going to be difficult with DOT, is the contractor claimed both differing site and superior knowledge. And we talked a little bit about superior knowledge last time. Basically, that means if the government or the owner has knowledge of a situation and they knew or reasonably could infer that situation may apply. And in this case, they had actually done, I think they excavated a pool and had encountered that same condition. So that's why I wanted to find the write-up, because I'm not sure if the same crew, basically if DOT does a job over here and encounters that situation, so within the organization they have knowledge, and then they do another job in a similar location and don't provide that, then they have superior knowledge as well as a differing site condition if it wasn't indicated in the plans. So a little bit of a different scenario. And that's why I think the conversation warrants a little more time, especially per comments we got last time, to have more examples. Okay, so and this is a little bit of a review of last time because we did talk about prejudice. So which of the following scenarios is most likely to cause prejudice to the owner? And Cord, my screens are taken up by everything, so I don't know if I don't have the chat in front of me. So here we go. Time to wake up. Let's see what's going on. So A, the contractor submits a signed change order after finishing the work. Is that prejudice to the owner? The contractor disturbs a differing site condition and gives notice 2 weeks later. Is that prejudice to the owner? The contractor lists costs in a spreadsheet. Is that prejudice to the owner? The contractor verbally mentions an issue during a meeting. Is that prejudice to the owner? So which one of these scenarios, so we talked about prejudice last time, which one of these scenarios is prejudice to the owner? I'm not going to show you the answer until somebody answers. So Cord, you got to tell me if people are answering.
No answers.
No answers? Come on, what was prejudice to the owner? Maybe I can sign in on my phone and see chats. Prejudice to the owner. Anyone? D. All but C. Ooh, interesting. A. Okay. Let's go back a little bit. We're going to talk about it. So, disturbing the site before giving written notice removes the owner's ability to inspect and adjust the work plan, and it is a clear case of prejudice. So remember, and we're going to go through this, and this is why we have kind of a workflow checklist or decision tree that we have. It's a draft, so we're going to finalize it. So prejudice is when the contractor takes our ability as the owner to act, to mitigate, to do something. So in this case, and again, we're going to kind of go through it. The contractor, once identifying or notifying on a differing site condition, must give notice. So they can't wait 2 weeks. And part of that HAR regulation is they cannot disturb the site. So they have to give you the ability to investigate the site as is to see if it is materially different than the contract. Okay, so thank you all for your participation so early in the morning. So that is prejudice. Let's talk about it again. What does it mean to prejudice the owner in the context of notice and claims? The owner must pay a claim that wasn't part of the original contract. Is that what prejudice to the owner means? The contractor disrespects the owner's authority, or those contractors. The contract or the owner's ability to evaluate, mitigate, or respond to a change is compromised, or the owner disagrees with the contractor's opinion. So again, which one of these do we have prejudice to the owner? Yeah. So again, this is a really important legal tenet because I believe this happens a lot and we just deal with it. And maybe the concept would be to really use this tenet and say, if you take, the reason we have notification is so that we can mitigate the situation. We might cut the scope, we might change the design, but if somebody moves forward without notification, it takes away our ability to mitigate or change that situation. So here we go, A, B, C, D, which one is it?
Most people say C.
Yay, that's correct. Okay, so the HAR, again, this is the Hawaii regulation. They must promptly give notice before the condition is disturbed. And again, we're going to have we'll go through next time a checklist of the investigation of the site. Failing to do so, again, waive, that means they no longer are able to do that. They're going to waive the claim unless the procurement officer grants an extension or determines the owner wasn't prejudiced. So that prejudice to the owner is kind of a key legal doctrine. Okay, so why is early disturbance prejudice? Prejudice in this context means the owner, DOT, or any agency is harmed or disadvantaged in its ability to inspect the condition as it exists, verify whether it is truly differs from what was expected or shown in the contract, and assess the appropriate cost and time impact. So all of these criteria exist, especially in differing site conditions. So we have to evaluate and make sure all of the things exist. So once the site is disturbed, the evidence is gone. It makes it harder for the owner to confirm whether the condition was really different. Was it different? Was it different than the contract? Was it different to the point, materially different? It was could have been caused by the contractor error. Was it already foreseeable? Like that's what we have to figure out. Prejudice equals the loss of the right to evaluate, and not just as a result of damage. So just the fact that we cannot evaluate the situation, that the contractor has taken that ability from us, that prejudice is enough to reject the claim. The contractor disturbs the site before giving notice. The owner cannot inspect the condition of the original site, or the owner loses the ability to decide whether a alternative approach is warranted. Then the owner has been procedurally prejudiced, even if the final cost or design wasn't affected. Obviously, it's a little bit easier to show when the final cost or design is affected, but it can also be prejudiced just by not providing that notification. Okay, so I want you guys to get comfortable with this term, really understand it. So we provided a ton of examples. And again, Cord did a lot of the work prepping this. So I want to thank Cord for doing a great job on this. Here are various professionally worded ways to say that the owner has been prejudiced, especially in the context of claims. So ways to say in plain language, the owner's ability to respond was compromised. The owner was denied the fair opportunity to evaluate the condition, lacked timely notice, preventing the owner from taking appropriate action. The owner's interests were adversely affected. The owner suffered procedural disadvantage, and the contractor's action deprived the owner of critical decision-making opportunities. On my jobs, I feel like this is one of my, the reason notification is important is because of all these things. And when they don't do it, it puts us at a disadvantage. I think the water line issue that still drives me crazy today, it was literally the contract said it was 300,000. We proceed. We don't think there's a material difference. We actually had a unilateral change order, and the cost turns out to be almost 15 times that amount, which is ridiculous. Okay, so here's a contractual legal way for saying the same thing. The failure to provide timely written notice resulted in material prejudice to the owner. The disturbance of the site without notice impaired the owner's contractual rights. The owner's ability to investigate, mitigate, or control costs impacts were frustrated. The late disclosure constitutes procedural prejudice under the terms of the contract. Such conduct obstructed the owner's ability to exercise the rights, and the owner's position was prejudiced by the loss of the opportunity, direct, alternate means or methods. And like I said, I'm just going to hammer this. So these are other ways to say it. The owner was unable to verify the alleged differing site condition due to the contractor's delay in notification. I don't even know how to say that word. I'm not going to say it. Impact occurred when the contractor proceeded without securing direction or authorization by unilaterally performing work and presenting an inflated cost after the fact. The contractor prejudiced the owner's review and cost control process, and failure to preserve site conditions for inspection materially impaired the owner's defense against the claim. So prejudice occurs when the contractor's actions or inactions interfere with the owner's ability to investigate, respond, or mitigate, even if no harm results. The hard part is you don't know. You don't know if you could have done something different because that ability was taken away. I think one of the other ways this happens a lot, although it might be similar situation, is when the contractor doesn't turn in a cost proposal in a timely manner, and then they proceed with work, and you think it's going to be within, a certain realm, and it comes back, just like I'm saying, 10 times, 20 times the cost anticipated. Then they've prejudiced the situation and taken away your ability to mitigate, make other decisions. Like I said, cut the scope, have another contractor do it. There are all these things that we could do. So again, I want to dissect this a little bit to help you all understand. So what is harm? Harm is any disadvantage, loss, or impairment to the owner's right, position, or ability to act, whether financial, procedural, or strategic. So Different types of harm to the owner. There's financial harm, direct monetary loss or anticipated costs that could have been avoided with proper notice or conduct. So here's some examples. Inefficient or unauthorized work. I think that's a big one. Understanding doing that analysis, is it efficient? Is it inefficient? And making timely comments, creating that record, because if you don't have the record, even as they're proceeding, if you don't have the record, a year later, it's going to be very difficult to show that, oh yeah, they were really inefficient. They had their worst guys out there, a bad crew. They would get maybe, half a day of real production, like all of those things. The inspectors will be out there making their observations, but the engineer really needs to chronicle it themselves to make sure we can document harm. There's procedural harm. It's a form of prejudice. So the owner loses the opportunity to act, decide, mitigate, regardless of actual dollar loss. So we missed a chance to eject, redesign, perform work with internal forces. Maybe there's an IDIQ that the maintenance guys have that could be used. You could put out a quick maintenance contract. There are other options. You are unable to validate the differing site condition due to the disturbance or prevented from issuing a proper change order and adjustment because maybe they didn't provide a change proposal. Going back to the last presentation, that's why I do like to use unilaterals, because it gives, the contractor has a mechanism to pay if they haven't given us a proposal. And at that point, it puts the burden of proof on them because they have to claim and they have to show actual records. The last is strategic or legal harm. The contractor's actions weaken the owner's position in enforcing the contract and defending against claims. So again, notice-based offenses, disrupting project controls or compliance requirements, overinflating their claims, overinflating their costs, all of those are prejudice. So this is another one, and I think this is a big one. So we've got prejudice, we've got harm. What does harm look like? And now what is that word material difference? So material difference is a substantial, not trivial variance in site conditions or circumstances that affect the contractor's ability to perform the work as originally planned, typically cost, time, and method. To justify a change order claim, the difference must be more than inconvenient. It must be material enough to impact performance or price. So to me, this is the hard part. So how are we going to analyze what this looks like? And this is the checklist. I know when I was going through it, it was a little bit this. So I want to get a little more of a structured checklist for the analysis. So step one is review what's in the contract. What was provided? What was the information provided? Were there disclaimers? The standard spec actually has disclaimers. Again, most of the time those disclaimers are actually thrown out because they really go by the reasonableness. Again, this is coming from the reference, so that's later in the presentation. So what is the legal test? Was there a representation by the owner? Either it was there or it was absent. But was there a representation? Was it reasonably relied upon? So again, the contract in 103 requires the contractor to identify anything that's wrong with the contract. So they can't come back and cash in on something that they were strategizing originally, right? That goes back to good faith contracting. We both are honest and fair with each other. Was it materially inaccurate? And that's the real test. And that's the hard part for people to accept, I think. Okay. Was it a patent obvious defect? Ooh, I feel like I had somewhere where I was going to remind you. Okay, so remember, what was patent versus latent conditions? Patent, if it was obvious, right? So this shows the big giant hole. It's obvious. If somebody went there, it'd be like, yeah, they're, having utilities in the wrong location, not really differing site because it's obvious. So those right off the bat, if it is obvious, It is not a differing site condition. And we can reject it just from that. So the Corps of Engineer principle, that's another reference that was used. Contractors have a duty to conduct a reasonable pre-bid inspection. So this is a legal tenet. It's in the 103 for our specs. It's in the law that the contractor has a duty, reasonable. So if you go to the site and you can see it, it's not a differing site condition. If the area had visible significant depressions and they were not accounted for in the bid, DOT may argue the contractor failed to do their due diligence, which again is in, oh, sorry, it's in 102, not 103. So step 3, did the contractor conduct a site visit? So again, we in our spec say they have to examine the documents and that it's their responsibility. So that's the disclaimer clause that is in the spec. But if the contractor fails to do that, it hurts the credibility unless the condition was truly hidden. So if you go there and it's kind of obvious, then that's not a material difference and it's not a differing site condition. Again, if we have pre-bid meetings using the logs and the RFIs to verify that that actually happened. And then in step 2, was it patent? Was it obvious? Could you see that the situation existed? So the next step to really think about, is it truly different and unforeseen? So are there similar DOT projects in the area that experience the same condition? Is there regional geological expectations, known site history, prior excavations? So again, this is not like, is it in the plans? Is it not in the plans? It's more than that. You have to think about, is it reasonable person? Would they make this assumption based on the contract, not solely on the contract? If it's not in the contract, that's not the full test. It's got to be not in the contract and a latent, unseen, hidden condition that nobody, a reasonable person, would never say. So to me, that's the quarry example. There's not one reasonable person that would assume that a quarry existed. I guess you could go back in historical records, but anyway, yeah. Okay, so what's the next step? We got to make sure we get notification that we preserve the record, that we have the ability to do a site investigation and fill out that form saying, yes, we went and looked at it, that the area wasn't disturbed, so that we understood what the condition was and it was in the original condition so we could evaluate it. The failure to do that would be an implied waiver on their behalf. At this time, we also want to start collecting the information, compiling it, having a contemporaneous record of it, just kind of keep notes, engage experts as early as possible. So obviously the geotech engineer, that's usually where these unexpected conditions are coming. Compare actuals to expected, analyze productivity impacts, support causation and damages. Is this, again, it all goes back to reasonable. Use your daily diaries to begin. This is a measured mild analysis. I may have Cord talk about that. Compare production and impacted and unimpacted zones. So lots of that. How do we measure the impact? So again, we're looking for material difference. If the condition differed than what was shown in the contract, or the owner, if the condition differed from what was shown in the contract, the owner may reject the claim if it had no added cost or delay. So again, there's 2 parts of this. It has to be material different, and it has to impact the contractor. There has to be added cost or delay. Obviously, delay is cost. Contractor cannot demonstrate the differing site condition caused any additional cost or extended the project, then there is no differing site condition. The same means and methods were used. So despite the variation, the contractor proceeded with the same crews, equipment, and production rate as originally planned. So I want you to think about, how do we know what they planned? Where does that information come from in our analysis? Can they segregate the cost? The burden of proof all of this is on the contractor. And so if they can't separate the costs, then there is no measurable impact. Schedule, float, or idle time is absorbed by the impact. So the condition may have occurred. It was also absorbed by available float and occurred during downtime. So it didn't delay the project or milestones. So there was no measurable impact due to the differing site condition. Then there's no claim. So we're going to evaluate merit by putting all of these things together. So examining the contract representation, reviewing the plan, spec, the geotech reports to determine whether the condition was reasonably indicated and whether the encountered condition materially differed from what was in those documents. Was it a lot different? Material, a lot different. Assess the site conditions and the physical evidence. So this is where you're going to do your site inspection. You'll gather that information. And again, is the condition unusual? Was it reasonably unforeseen by a prudent contractor? Again, lots of words in there, but we're looking for, did the DOT do the best job they could in presenting the information? Did they withhold any secret things that they could or should have known about? And did it impact the contractor? Did he have delay or cost? Then all of those things taken into consideration to see whether it is a differing site condition change. So determine if there's a material difference, whether the difference affects cost, not that it just exists. Look for abnormal conditions in quantity, difficulty, or nature of the work. Check the documentation and timing. Was the required notice submitted before the area was disturbed? Are there daily reports, force accounts, etc., that impact the substantiation of that claim? So this is the last step in that analysis. Here's some of the resources that were used. This on the right, the ASCE Press, that's actually the book that there's chapters in that book that we're following as the outline for this series. When Cord posts this, he'll also add the guideline for the evaluation of differing site by the Corps of Engineers. Again, we want to make sure we're identifying the criteria, contract representation. Did the contractor make reasonable reliance on that, or was it unreasonable? Again, he can't just say, or they can't just say it wasn't in the contract. You have to look around. Was it at the site? Was it obvious? Should they have known it? If they should have known it, then it is not a differing site. Actual differences, make sure they provide notice, and then they have to have an impact. So all of those things have to be met. Useful framework for both contractors and engineers in managing jobs. Again, that notification, being able to mitigate, evaluate, all is part of this process. Okay.
Kai, before we move on, there's a couple of questions that have to do with the last couple of slides. So I know I was asking, what if the differing site condition is obvious, however the access to the site is difficult or not safe, for example, stopping on the side of the road or in a small shoulder?
You mean it's obvious, but they would have had to go through extraordinary. Well, I don't know if I think that's extraordinary. I think if it's obvious, then that is not differing site. So you're kind of saying that the access, it would be difficult to get access. So I think it depends. And it also depends what was represented in the contract. So was there a required site visit that everybody went to? If you go there again on your own, is it obvious? I think that's the patent defect. And it really goes back to what was the representation in the plans or not. If they said, make sure you do this, if they said there might be whatever the condition is, then the plans are trying to give you notice of it, and then you would have to look at, does it materially differ? Because I think there is an obligation on our side as the owner to put out the traffic control and go do that investigation and annotate something in the plans. So if we didn't do that, it might be materially different. I don't think accessing the area is alone gonna say whether it's a reasonable, because if you can see it, I think it's patent, and that you would have to, that it's not different, and they should have known. What was the others?
Oh,
Word.
well, I know I just clarified, and he said, or something they can see, however, hard to get a good grasp on the gravity of the situation because access is hard or unsafe.
Again, okay, we're gonna cover this. Uh-oh, my door's open. So the contractor under 102 also has the what is that called? They have the obligation to ask the question during bid. So if it was obvious and they didn't ask, then they have failed. And I think I wrote it up, but they have failed to they have failed their own due diligence. So again, they can't go look at it and then say, ooh, nobody's going to know this, so let's not say anything. And then when we get the contract, we're going to come back and say, oh, that was differing site, it wasn't in the plans. So if it's obvious and they can't access it and they don't understand the depth of it, then during bid, they have to ask the question. And let me go through, because I think I have something in here that addresses that. If not, Cord, let's come back to it, but I think I had something on that. So this is a scenario, wet soil conditions. I don't know if any of the Kauai people are here, but this is kind of their example. Contract indicated wet soil conditions could be encountered and would be paid by force account. Wet soil was encountered as anticipated in the contract. The condition occurred as described, and the contractor was paid by force account for time and materials on the wet change. Now the contractor claims, had we known the extent of the wet condition in the base scope, we would have had different equipment and would have cost less, so we should be compensated differently for base scope work. So they weren't even asking on the change work. They're now asking for base scope work or the shoulder work that they now, because of the wet condition, it's different, and that they have to reprice the base scope. How would you evaluate the claim using different equipment than originally anticipated? So what information do you get as the owner, as you're starting the project, your pre-construction submittals? How would you evaluate what equipment they were planning on using versus what equipment they did use? So put that in the chat, because I think that's an important, how do we evaluate what was anticipated? So let me know if people are putting in the chat. We'll talk about it in a second. So let's go through the steps. Is this a valid claim? So number one, was there a representation by the owner? Was it reasonably relied upon? And was it materially inaccurate? So what was the representation by the owner in this situation? So now I got to see if I can get the chat going. Anyone? What was the situation? Here's your cheat sheet right there. What was the situation? Anyone? Right in front of you? Wet soil conditions? Oh, yes, wet soil conditions. That's what it is. Yeah. So wet soil conditions, now I'm ooh, there's lots of stuff in there. Okay, so wet soil condition, and it was represented in the plan, right? So there was a representation. The plan said you were gonna run into wet soil conditions. Is this an obvious defect? Now, let me see if I wrote this in there. Okay, what may not be obvious is this situation is on Kauai. So what is Kauai known for? See if there's any responses. Does it rain in Kauai? Yes, thank you. Being wet. So So the representation of the plan said they're going to run into wet soil. We'll treat it. It told you you're going to treat it by force account. Was it obvious? I actually did a little bit of research, and this area is expected to be 50% wet. So if you did a little bit of due diligence, you would understand that yes, wet conditions, and then you're going to have to assume something in your contract. So again, they'd have to do that. I kind of feel like 50% assumption might be a good assumption if you look at rain records or something like that. So there's got to be a due diligence, especially since the owner made the representation. So did the contractor conduct a site visit? A contractor's failure to perform a site walk may hurt their credibility unless the condition was truly hidden. So this goes back to the patent. That goes back to reasonable reliance on the contract. Is it reasonable when you know the contract's saying there's a wet condition and you know the area is wet? You probably should be asking the question during pre-bid. And if you don't ask the question, then again, it's your fault. You didn't perform due diligence under 102. So is it truly different and unforeseen? So we'd have to examine, are there similar projects in the area nearby? Regional geological expectations? Does the site history give somebody, again, reasonable? Is it something obvious? We want to preserve the record that misrepresentation caused them to choose a less efficient means. And the other part is they have to be harmed, right? They also have to provide their timely notification. So we want to make sure all those things were done. Let's go. Okay. Now, this was my question. So again, they're coming back and say, it's not about the change because we've already addressed the change through force account. They're actually coming back and saying, well, now our base bid was wrong because we didn't factor this in. So this is kind of important, and I didn't do a deep dive, but we can if you guys feel like we need to. But the contractor chooses the means and methods. So unless we direct the means and methods, the contractor assumes the risk for productivity, efficiency, equipment. They're responsible for their bid. They can't reprice base work just because they would have done it differently in hindsight. Because again, was there a material misrepresentation? If you know it's a wet area and you run into wet conditions, and we've addressed the differing site through force account, then what are they entitled to in the base bid? So again, wasn't materially different. If the plans or spec clearly stated the condition, wet soil, and it turned out to be 100% of the shoulder, this might be a material difference, but the contract was, if it was ambiguous, non-committal, and the contractor did not ask for clarification during bid, that weakens their claim significantly. So I want to stress, like, all of this, that's why engineers are running the job, because you have to be able to do these kind of evaluations. Otherwise, we wouldn't have to be licensed engineers running a job, or licensed engineers being REs or construction engineers. So there is some experience that comes with this. Obviously, the owner, it's a negotiation. All of these things go into whether you're going to accept the claim or not, because I don't know which class we talked. I think it was a while ago, but at some point you're going to settle the claim. You're either going to pay, you're not going to pay, you're going to go to court. Something has to be settled. All of these factors go into whether you as the owner are going to say, no, I'm not going to pay. It gets elevated. Does it go to court? Again, a lot of this hasn't been tested because most of the time DOT settles. So these are the legal tenets that we can stand on. When everybody's doing it consistently, I feel like there's a stronger chance of success for DOT, and the legal precedent actually exists. Okay, so this is the part I was going to talk about with the owner. So the legal principle is the duty to inquire. So both the federal and state law include this. If a reasonably prudent contractor would recognize an ambiguity or a gap in the bid documents, They are required to seek clarification. Again, this is under 102. I don't think I stated that language. We could pull that, but they're required to seek clarification before bidding via RFI or pre-bid questions. So the failure to do so may result in the ambiguity being interpreted against them, not the owner, because they didn't perform, they didn't follow through with their duty to inquire. If it's a wet area and there's wet conditions and you're basing your bid, or you're assuming 50% or whatever you assumed, and you don't ask, you've failed to inquire. That's their breach. So the contractor noted wet soil encountered 100% instead of 20% that they assume. Did the contractor ask the question, how much wet soil should we anticipate? They have a duty to inquire. In this case, the contractor may be barred from claiming differing site condition because the ambiguity was apparent and they failed to seek clarification, and there was no materially different situation. Again, maybe if you're on the leeward side and it never rains and you encounter this, but obviously the owner understood there would be wet soil. No one's going to be able to tell you how much wet soil. Actually, I did put it in here. Good me. 102, bidding requirements and conditions. The bidder shall examine the site, the plan, the specs, the contract forms before submitting. Submission of proposal should be considered a conclusive evidence that the bidder has made such examination is satisfied with the conditions to be encountered. A bidder cannot base assumptions and later claim a differing site condition. The ambiguity was patent or obvious, and the contractor did not seek clarification prior to bid. So again, I don't think this is anything that's been tested, but maybe it should. I got my little reminders here. Okay, let's go on. So here's an example. Cord, you're going to walk us through this?
Yep. So
Okay.
thanks, Ben. I know we only have about 10 minutes left, so I'm going to kind of run through this case study and also the following slides as well pretty quickly. I know we also have a bunch of questions in the chat that we should probably go through as well. So I'm going to run through this stuff. There's going to be a good amount of words, so we will be for sure to send this stuff out and all of the references that go along with it posted on the wiki site for your reference. But anyway, here's a case study that we just made up, but wanted to use this case study to also provide support on some of the legal doctrines that we'll go over that the contractor can potentially exercise. But we'll go over after that. So essentially location, leeward of Wahoo, planned versus encountered. So what was planned and expected, trenching and weathered basalt with minimal support, but what actually was encountered is voids, groundwater intrusion. So just wanted to paint a picture of something that was planned and expected, but then what was encountered was different. So just providing a case study and example, but also utilizing visual aids. And I know for the first two trainings, for last training and this training, we harp on documentation, right, to support your side and justification for potential claims from the contractor in potential situations like this. So next slide. Okay, so some legal doctrines that can potentially be exercised, and I know Kai mentioned a couple of them, like superior knowledge before, so we'll quickly go through some of these that could potentially be exercised and related back to the case study that we just went over. So implied warranty of accuracy, Spearin doctrine, the application state by providing soil reports, boring logs. Again, a lot of these differing site conditions have to deal with underneath earthwork, groundwork, all of that. So soil reports, things that can't necessarily be obviously seen, right? So that is something that wanted to reiterate, you have to look for. Soil reports, boring logs, plans implicitly warrants their sufficiency and accuracy. So based off the reference and originating from US for Spearin, this principle is recognized in state contract law through HAR and also case interpretations. So relating back to the case study, if HDOT's contract documents include misleading soil profiles or omit information, the contractor can argue breach of this implied warranty. So that is one example. Additionally, constructive change doctrine. So if contractor incurs differing site conditions and it meets all of the requirements that Kai went through and directs extra work without a formal change order, constructive change may have occurred. So even without a written change order, contractor is entitled to equitable adjustment in the 104 methods of adjustment to owner-directed scope expansion, and specifically to the case study, DOT field personnel required immediate trench redesign or safety measures. This would support a constructive change claim. And obviously you have to follow the proper procedures and notices and all of that. So that's why that was part one of the training. The next slide, we'll go through a couple more, some of which are already mentioned, Kai already mentioned, and as you can see on the bottom there, doctrine of superior knowledge. So just to go a little bit more into detail, if the owner possessed critical knowledge but failed to disclose it during bidding, claim may arise. So the government has a duty to disclose information materially affecting performance, as Kai went through, particularly when the contractor had no reason or ability to discover it independently. So obviously that would be going through their independent site investigation, their due diligence. So if they had no reason or ability to discover it independently through their due diligence, then that is when this could potentially be exercised. And then specifically to the case study, if HDOT had previous projects or geotechnical reports in the area indicating groundwater that was encountered, but did not disclose them, this doctrine could then apply. And then again, equitable adjustment. Sorry, if you go back, Kai. Equitable adjustment. So we have specs, right, methods of price adjustment, and we will, in subsequent training, I know we wanted to go through more detailed examples of going through cost justifications and going through the cost impact of various different changes. So not going to go into super detail here, but when it comes to this case study, DOT's boring log showed benign soil, but water intrusion was encountered. Contractor relied reasonably on those representations. So next slide. Moreover, and this is duty to disclose constructive notice, application related to superior knowledge, as we discussed before, applies when the owner had data that could materially, that's important, materially affect cost and schedule and failed to disclose it. And then mutual mistakes. So when both parties enter a contract based on a shared mistaken belief about a material fact, for example, subsurface condition, again, in which most of the different site conditions cases are, recession or modification may be justified in that scenario. And when it relates back to the case study, both HDOT and contractor expected stable trenching conditions, but water intrusion was unknown to both, so it would be considered a differing site condition. Next. And Kai mentioned this before, good faith and fair dealing. So every contract includes implied covenant of good faith. So if the owner acts unreasonably, rejects reasonable different site condition claim, it may breach its duty. And then finally, administrative appeal rights. So generally require first level dispute resolution with the engineer, followed by the HAR, administrative appeal. And then for an example of this case study, if differing site claim is denied, the contractor may elevate claim through administrative channels. And again, we discussed this in the first training. Obviously, you try to deal with it at a field level, but if you cannot come to an agreement, cannot come to a settlement, then obviously things have to be elevated. We don't want to keep it at that level. We want to elevate and move things forward so that things don't further get delayed. So next. Again, briefly just wanted to go over some supporting evidence. So some of the documentation that you could look at, owner's engineer's estimate. So if it's nearly identical to contractor's pricing, validates reasonable expectations, right? And maybe potentially not, differing site condition, and it's potentially was reasonable and not too unexpected. Bid spread analysis and also public records. So obviously we want to be able to take a look at all of the different documentation that's provided for us in any change or claim, but in particular, differing site condition. We want to make sure that we have all the resources to evaluate properly. Next. So when claiming additional time or compensation due to DSC, contractor must prove all of the required elements. And obviously, safety or simply stating the site was different is not enough documentation to support a claim or change that will likely follow. So the 4 elements that the contractor must prove. Number 1, the condition was materially different, and obviously we've said this multiple times now, but the condition must be materially different from what was indicated in the contract, the patent defect. Second, the reasonably.
Yes, right. It's not a patent.
It's not a patent defect. Yep.
Yeah.
Yep. Just wanted to clarify that. And then secondly, they reasonably. Oh, sorry. Go ahead.
Yeah, I'm just going to take up. So did they reasonably rely on the contract? So unreasonable reliance on the contract would be they only looked at the contract, they didn't do a site visit, they didn't think about the conditions that would be obvious in the area, like rain in Hawaii. Did they give timely notice? So again, we pounded this. These notice requirements are different than the other ones we talked about last week. So it was, within 12 hours by 10 a.m. the next working day, and then I think it was 5 days. So that's where the infograph will come in. And the difference, again, the last part is the difference had to cause an increase in cost or delay. The contractor must prove the condition was different, reliance was reasonable, notice was timely, and the impact was real. Otherwise, the owner is not obligated to pay a differing site condition claim. So that's what when we talk about the checklist next week, we'll talk about that because I know we're running out of time. So again, production impact equals a dollar impact. Method for calculating damages. So that's probably something we'll do in the next one. What are the total costs, modified costs? We are going to just talk about damages in general in a session because all of these evaluations look at entitlement. Is the contractor entitled to an equitable change due to these conditions? In this case, we're talking about differing site conditions. But once we say yes, they're entitled, there is merit, which we would want to respond in writing, then we're going to have to calculate what are those damages. There's the pitfall, including maybe not including contractor owned equipment. Maybe we're not looking at time, but we should be. And then differing site condition claims do not require a delay analysis unless they're talking about time, which when we circle back on time, again, both components of this is cost and time. And if there's a time impact and we concur there's an impact, then that analysis would look at the cost of that impact. So that's going to be the follow-on to the schedule series that Joel's been doing. So again, tips for presenting this differing site condition. This is more geared towards the contractor, but we planned for X, encountered Y. So you would look for these kind of things in the write-up they're giving you. Is what was expected versus actual, highlight the impact on production, reference the owner's estimates. Now, the contractor doesn't have this, but and I'm not sure if we put this, it's probably going to be in the follow-on, but one, and Cord just mentioned it. One way to look at these analysis is what were the other bids? If you look at the bids and everybody's bid is kind of in the same realm and it matches the engineering bid, that's one way to evaluate if it was materially different. If the contractor's bid aligned with all the other bids and the engineers, then everybody kind of made the same assumption because the analysis of the bids shows there wasn't a huge difference in cost. So that's one way to justify our position, saying, wait a minute, you guys are in alignment. And then the other way, and I think Ben put it in the chat, I tried to, while Cord was talking, do some responses. When we look at their baseline, when we look at their method statements, what did they say they were going to do? What was planned and what was actual? So there are those things that you can look at to see if there was a material difference. Again, some notable points. utility conflicts, maybe, I don't know about endangered species. I probably should take that out. Burials for sure. Endangered species, we kind of know where they live. We kind of have that. And then again, false claims, them submitting or exaggerating claims, although I don't think we've ever pushed back, but it's not in accordance with the contract. It's not in accordance with the law. Okay, so here's some key points. Must show clear link between the differing site condition and increased cost and delays. So again, if it's different and there's no cost or delay, there's nothing. Notification is a condition, right? We talked about that. They have to notify it. They cannot disturb the site, and you have to go and do that site evaluation. So that's what we're going to do next time. Always check the HAR, the law, and the contract. I know some of you guys do a really good job of that. And then what we're going to do next time is more examples, the site investigation checklist, a little bit of the decision tree, because I know we had 4 points and 7 steps. So I feel like that's a little confusing. So I wanted to kind of streamline that. And then example responses to this. I know the last training we had great comment come saying, I'd like to see more of these things. So instead of just doing it all, next time, I think we'll have a little more conversation. We'll have these examples. Appreciate the participation in the chat. Oops. And that's the last slide, as I'm trying to get rid of this notification that it won't let me do.